Alrighty. So welcome everybody. If you are here for the webinar on accessing transition services with students with disabilities, you are in the right place. Go ahead and go to the next slide. So today you are going to be primarily hearing from Brad Demps, who's a lawyer with Matt Cohen Associates, who has graciously donated his time to chat with us as well as all of you today. For those of you who are not familiar, Matt Cohen Associates, it's a small civil rights practice concentrating in special education and school-related issues, legal challenges associated with mental health needs and human service providers, as well as working with families on the needs of children and adults with mental, developmental, and physical disabilities. So we are going to be primarily hearing from Brad today. Jen Moriucci is the clinical director for the Arts Center and the outreach director for the Arts Center. We are going to be here to touch on any clinical questions that come up, talk a little bit about some of the clinical considerations as they relate to transition needs and services, as well as some of the resources today. Go ahead and go to the next slide. As I mentioned, the bulk of the time today will really be spent on legal considerations. So Brad will be able to touch on the overview of transition planning prior to COVID-19, as well as the impact of that on learning and remote learning requirements, as well as some tools and strategies to advocate for your child, both during and after remote learning. Go ahead and go to the next slide. I want everyone to be aware that you are automatically muted and without video. There won't be an opportunity to turn on your video with us. The recording will just include the panelists and the speaker for today. If you have questions or would like to submit questions throughout, there's a couple ways to do that. You can utilize the chat feature, which will come to the panelists directly. You can use the Q&A feature. Oh, you always have the option to hit anonymous if you'd like to make sure your name is not included in that question that you ask. And then towards the end, if you prefer to use your voice, you can use the raise hand feature and we can unmute you. That will not allow a camera to have you as part of that viewing, but it will allow the recording to have your voice. Again, any questions can be submitted throughout. As they make sense, I'll moderate and try to jump in and include any of those questions. For the most part, they will be saved for the end. All right. With that, I'm going to hand it over to Brad.
Okay. Hi, everyone. I am Brad Demps. As Holly mentioned, I'm an attorney with Matt Cohen Associates. I have been practicing special education law on behalf of parents and children with disabilities for about a decade now, first in Michigan and now in Chicago for the past 4 or 5 years. So I'm here to talk to you today about transition services for students with disabilities, which is a pretty overlooked topic. And I've tried to think about why that's the case. And I think in part it's because of the structure of the IEP meeting and how often transition is left for near the end and is often discussed quickly or in a more summary type way. And I think that parents just often don't realize how important this aspect of the IEP is and how important it is to plan for the next step in your child's life and to take a proactive approach to doing so. I'm sure that all the parents who are here today and a majority of parents who participate in their child's IEPs are concerned about next steps and probably wondering how the school district can be involved in getting the child ready for those next steps. But for one reason or another, transition is something that often falls by the wayside or is something that is considered something to address later. So we'll talk today about what the actual requirements are for transition services, what you're entitled to, what your child is entitled to, and really the timeline for when you should start thinking about that. So first, just to note, this says the new FAPE standard. There was a Supreme Court case the United States Supreme Court in the case called Andrew F., which you may have heard of. It was the most recent landmark case in special education law. I think it came down from the Supreme Court and made their ruling 5 years or more ago. So we're well within this new era of Andrew F., but it's still technically the new standard. And essentially what Andrew F. says is that a free, appropriate public education has to be based on challenging goals that are determined based on a child's individual circumstances, that a child has to receive more than minimal benefit. So saying, oh, they increased a little bit in their reading ability, that may be okay, but what the real question is how much are they capable of achieving, right? And have they made progress commensurate with their potential? And a note here that passing from grade to grade is only one measure of progress or lack thereof. So we'll talk a little bit more about the considerations for what appropriate progress looks like as we move on. But the purpose of highlighting the FAPE standard, Free Appropriate Public Education standard, at the outset is that transition plans need to be linked to goals, what we call post-secondary goals. So post-secondary meaning goals that are looking ahead to where we want the child to be able to achieve when they're done with high school, when they're moving on to the next phase of their lives. So because of this Andrew F. standard for FAPE, it requires some more ambitious planning. So what a transition plan has to include involves, again, post-secondary goals that are appropriate and measurable. So appropriate meaning that they're providing or that they're looking at what the child is actually capable of achieving, and measurable meaning that you can actually define progress and measure it based on how the goal is written. So that usually involves making sure that the goal is based on an actual present level of performance, and then identifying how you want the goal or how much progress you are expecting the child to achieve within a set period of time. So you can really hone in on whether that progress has been achieved. So we often see IEP goals that are vague or that include several skills in one goal, sort of compounded. And in those cases, it may be hard to determine progress. So we always advocate for the goals to be as measurable as possible and based on the child's current performance. So, and that's where the next part comes in, that the goals should be based on age-appropriate transition assessments, including training, education, employment, and independent living skills, if that's an area of need. So those are all aspects of transition skills that a child will need to develop as they grow from being a child to being a young adult and moving on from education to community living, employment, and all those sorts of things. And then once we have goals in place, just like with the regular part of the IEP, once we have transition goals in place, we determine what services and supports are needed to assist the child to achieve those goals. And that can include specific courses of study. It can include accommodations and related services, just like the rest of the IEP. And by the way, if you see strings of letters and numbers that don't make sense to you, and you're wondering what those are sites to the specific area of the federal law that provide this information. So that's just there in case you want to follow up on the law itself. But of course, if you're not an attorney and you want more information about how to interpret the law, we always advise you to consult with an attorney or an advocate for that type of information. So post-secondary planning is the time period when you are starting to develop your transition plan and looking ahead again at what this young adult is planning to do after school. Business as usual in an IEP before transition is considered is usually an annual process where the IEP team meets and takes a look at the IEP and determines what progress is expected for the coming year based on what the child was achieving the previous year. And progress is typically incremental, moving forward step by step. Now, when you're looking at goals based on post-secondary planning, you're really starting from the future and working backwards. So you're developing long-term goals before you develop the short-term goals. Okay, so post-secondary goals really inform what you need to be doing in the present to allow the young adult to end up at a place where they're achieving those post-secondary goals. And just like every other goal, as we've mentioned, post-secondary goals must be appropriate and achievable. So when we say achievable, we mean realistic in light of the child's unique circumstances. And that goes back to the NJUF standard of what a free appropriate public education is. So this is essentially a whole new approach. Given your appropriate goals, as I said, the annual goals and the services have to be driven by the post-secondary goals. So that's significant because it changes the mindset in terms of how you're looking at goals. You're not just saying we want the child to improve it by 5 seconds in their rate of reading over the course of a year, just to throw out a random example, but you're saying we want this young adult to be able to have a job where they need to communicate with people and to be able to tolerate feedback that may not be positive. For example, if you have a child who has a difficulty in social interactions in that regard. So looking ahead at how do we prepare this young adult to be a functioning member of society and to have a job where they can accept and respond appropriately to feedback. Now from there, you work backwards and say, okay, what social work goals do we need to implement now? What services do we need to include to allow that child or young adult to improve in that area of skill deficit? And looking at it in this way may require schools to expand the scope of a child's needs, broaden the goal areas, add programs, add services, and potentially even continue services beyond the typical graduation date. We'll talk more about that down the line. But the point of emphasis here is really once your child reaches transition age, it's time to start thinking forward and working backwards rather than continuing to just do business as usual with the IEP. And school districts may be resistant to doing that, but this is well within your rights and what you should be expecting. So if they're not taking it seriously, there are several things you can do to address that we'll talk about down the line here. The timing of transition planning is significant. So the IDEA, that's the Individuals with Disabilities Education Act, which is the main law that we're operating under that provides guidance for us and for families and for districts on what the requirements are, what your rights are. That's all included under the IDEA, which we refer to as the IDEA. So the IDEA requires transition planning to start at least at 14 and a half in Illinois. Some states differ, but I'll mostly be focusing on specific Illinois requirements here. And just as a point of clarification, the IDEA is a federal law, so it applies the same across all states, but specific states like Illinois can implement additional regulations that add to, not take away from, the rights under the IDEA. So for transition planning in Illinois, the state has specified that this should start at 14 and a half. So whichever IEP is in place or will be in place when the child turns 14 and a half, that's the first IEP that needs to have a focus on transition planning. And the courts have determined in multiple cases that the failure to timely conduct transition assessments and implement transition plans is a denial of a free appropriate public education, or FAPE. So when you see names here, something versus something else, those are cites to court cases or to due process hearing decisions that that provide the result that we're referencing here. So 14 and a half is really when they're required to start transition planning. But as parents, you should start thinking about transition planning before the statutory mandate, before 14 and a half. So you're sort of prepared yourself to know, what you're looking for, start to understand certainly what your child's needs are. That's an ongoing process of understanding and shifting depending on how they develop their skills or don't. And then thinking about where you ultimately want them to end up, what they can realistically be expected to be able to do in the future, and importantly, what they themselves are interested in and want to do, right? That's of paramount importance here. And we'll talk a little bit more about that as we move on. Okay, sorry about that. So the student has to be invited to the IEP meetings, but they don't need to attend if they're under 18. That's up to you as the parents. In some cases, it's helpful to have the student there for one important reason, to allow them to become more familiar with what planning looks like for them. As they get older, they will most likely be more involved in the process to whatever extent they're capable, and they will be part of the team in terms of providing insight into their needs and their interests and their own goals for themselves, again, to whatever extent they're able to do so. Up to 18, though, parents retain the right to decide if the child should attend the meeting. Certainly, sometimes it's not appropriate. For one, if the child is not capable cognitively of understanding what's going on, it may not be appropriate to have them involved for the full meeting. In some cases, it may be awkward when you're talking about a child in front of them, and when you're having frank and honest conversations about what they can and can't do, that could have some emotional impact, understandably so, on a child. So those considerations, among others, may guide parents to decide not to involve the child in the meeting. And you can also get creative and be flexible about if and when your child attends an IEP meeting. If it would be helpful to have them join in at the end to get a summary of what was discussed and any changes that were made to the plan. If it would be helpful to have them at the beginning to share their input on what they would like to see included in their plan, and then have them go back to class or leave the meeting. Those are both options that you should consider depending on your child's needs. And then also, outside agencies have to be invited if they may be asked to provide services to meet the transition plan. So an example of that would be vocation rehabilitation services from the state. If your child may be receiving supports from Invoke Rehab, that could include someone to assist them in performing a job, that may be a reason why that agency would be invited to participate in the meeting. And the school district is not allowed to say that they can't participate in the meeting. So then when students turn 18, parents lose the right to participate in the process at all, or make any educational decisions on behalf of their child, unless the parents obtain legal guardianship, or if the student signs a delegation of educational authority form, or a delegation of decision-making authority for education. This is a form that is always revocable by the student, but oftentimes when we have a student who may not, either parents don't want to become legal guardians, or it wouldn't be appropriate for them to take that type of restrictive control over their child after the child turns 18. Oftentimes we suggest that parents have their children sign this delegation form, and essentially that continues the parent's ability to be the decision maker for educational purposes. And then just to mention, there are also various power of attorney forms that can be signed or arranged for various types of decision making. The delegation of educational authority form isn't exactly a power of attorney, but it essentially has the same effect for the purpose of participating in IEP meetings. So we'll talk a little bit about the specifics of transition evaluation. And here we note a case. This was actually a case that I litigated that we won, in which the hearing officer found that just doing a sort of an interest inventory, asking the student what they were interested in, was not sufficient to fulfill the evaluation requirement under the IDEA. A formal transition assessment, we'll talk a little bit more about what that involves, but it's more than just figuring out what the students and the parents' preferences and interests are, right? You have to also assess the student's ability to meet goals in those areas of interest. And in this case, we had our client was a young lady who was very interested in working with children. She always had an affinity for her younger siblings and for children in her family, and that she'd see out in the world, but she didn't have the cognitive ability to be a teacher, for example, and yet this school district said, oh, you like working with kids, I guess your transition goal will be to become a teacher. Okay, so that wasn't realistic, unfortunately, in the immediate term or in the future for the student, and yet they started planning around it as if it was possible. So while we certainly want to be ambitious, we have to also be realistic so that we're not setting our children up for failure or disappointment when they're unable to achieve the goals that have been set for them. Okay, so just conducting an interest inventory is not enough. You have to assess the ability to meet the goals so that the goals are realistic. And importantly, evaluations and the transition plan have to address non-academic needs. Okay, so academic performance is only one part of educational performance. And this is why passing from grade to grade isn't on its own enough to determine if a child's making appropriate progress, right? Because there are other components to education that are non-academic, including social skills, emotional functioning. Functional needs could include planning, organization, motor skills, speech and language skills, communication. All of these things are part of what an appropriate education needs to address, to the extent that there are areas of skill deficit for the student. And then also just to note, a generic or non-individualized assessment is not sufficient. So it starts with real assessments. And real assessments can be informal. There are a lot of measures of transition skills that are informal, like interviews and questionnaires, just observing the child to see what they can and can't do, curriculum-based assessments to understand their functioning on academic tasks. Various school performance measures can be indicative of needs, and planning inventories. Those are informal ones. And then more formal transition assessments include specific achievement tests, and the list goes on. Notice we say interest inventories are a formal transition assessment, and they are the most common thing that is done, but they're actually the least useful. Okay, so the best type of assessment is what's called a functional vocational evaluation, or FVE, and that is a more in-depth examination of all the child's needs across areas of functioning, and if it's a quality evaluation, it'll also include recommendations for services moving forward to get the child where they want to go in the future. So interest inventories can be okay if they are a part of a larger parcel of evaluations, right? They're not enough on their own. We really need to look more specifically and broadly at the same time, right, at all of the child's needs. So once a transition evaluation has been done, that informs the transition plan. And again, the transition plan is the component of a component of the IEP. So it has the same legal effect as the rest of the IEP, meaning once it's agreed to and put down in writing as a part of the IEP, it has to be implemented as agreed upon. And if it's not, you can hold the school district accountable for failing to do so. So the contents of that transition plan must be an actual plan. Imagine that, for how goals are going to be accomplished. They can't just continue goals from earlier in high school and say, oh, your child's still working on their reading skills or their communication skills, so we'll just continue these goals. It may be appropriate to continue those goals, sure, if that's still an area of need, but it needs to be done with a consideration, again, for the future, looking ahead. What does the child need to achieve to be able to accomplish the ultimate goals as they transition out of public school? And again, just to emphasize, this plan has to address academic and social, emotional, executive functioning needs, and include whatever supports are necessary to facilitate skill development. It's also important to note that a lack of clear student direction doesn't negate the school district's obligation. LEA stands for Local Educational Agency, and as you've probably noticed by now, and probably have experienced outside of this presentation, this area of law and special education in general is kind of an alphabet soup. So I tried to make sure that I'm identifying the acronyms that we're using, but if you have any questions or concerns about things that you see that you don't know the definition of, please feel free to put a question in the chat or ask at the end if you take a note of that. But LEA is the school district. So the point of this slide is that if a student has, as this case instructed, if a student has been absent or they're not sure what kind of career they want, and they're just sort of, floating through without direction or without being able to nail down on their own what they're interested in, that doesn't excuse the school district's obligation to provide appropriate transition services, right? The school district, is the one who has the obligation, not the student. So it's helpful to have the student's feedback. Certainly, it's necessary, in fact, to solicit and request the student's feedback. But if a child isn't willing or isn't capable of providing that type of input, the school district still has to conduct appropriate evaluations and develop an appropriate transition plan. And in fact, if you think about it, a child's lack of direction might actually increase the school's obligation because it indicates that this student doesn't know enough about what they want and is sort of at a disadvantage because of that. So they really need additional guidance from the school, not only in planning how to achieve their goals, but in identifying what those goals are in the first place. There's some other examples of a school district's responsibilities. They can be required to provide remedial programming that's necessary to ultimately participate in a vocational program. So for example, union programs or learning specific trades may require functional literacy. So if a student is reaching the end of their educational career and they're still not at that functional literacy level, the school district should provide a remedial reading program to assist them in catching up to achieve the level of reading skill that's necessary for them to participate in that type of union or trade program. And just thinking about it critically, if the child is reaching that age and they're still unable to read, it may indicate that the school district hasn't done their job sufficiently to get the child's academic skills to improve up to that point. And again, this is all based on a child's individual abilities, right? So if it's simply the fact that this child won't be able to learn how to read functionally, then you have to question the ultimate transition goal, right? If they're trying to participate in this union program, but the truth is that they really won't be able to, then that's not a realistic goal for them in the first place, and should have been either not included as a goal in the first place, or when they realized that the child wouldn't be able to achieve functional literacy, the goals should have been adjusted and the plan should have been changed accordingly. It's also important to note that this type of planning, just like the IEP, is necessary to amend and adapt as you go along, right? So the school district's required to have an IEP once a year to check on progress and update goals, but there's nothing that prohibits them from meeting more regularly. And if you as the parent feel like you've noticed something concerning, or if you've gotten input or feedback from a private provider that's working with your child, like an ABA therapist that has some insight to share, you can always request an IEP meeting at any time to review that information, and the school district should oblige and schedule a meeting. And I say should because it's not always the case that they will, unfortunately. But in those cases, you may have to file some sort of complaint, and we'll talk a little bit about that at the end. So we touched on remedial programming. There's also explicit vocational programming. Okay, so there's the example here is the Triochi Salon, which some of you may be familiar with, but this is a salon in the Chicago area or surrounding suburbs that has a specific training program for young adults with disabilities to learn how to cut hair or to work in the salon. So that's something, if that's an interest of your child and something realistic for them to achieve, that's something that the school district can be required to pay for as part of the transition programming and transition plan. There's also an example here at the end that's typically only something ordered by a hearing officer, but that's the creation of an escrow account or a fund to be used by the parents to underwrite the costs of this type of programming. So we'll talk a little bit about compensatory education in just a few minutes, but if your child hasn't received the appropriate educational services or supports that they're entitled to, and you go through the hearing process, a hearing officer may order the school district to set aside a certain amount of funds that can then be, is an account that can be drawn from by the parents to pay for the costs of programming, like the Triochi salon or anything else that's appropriate for the child. So again, as I just mentioned, the plan has to be reviewed at least annually, emphasis on at least. And the district has to carefully consider whether the post-secondary goals and services should be updated to align with the student's current interests and preferences, or if they continue to be appropriate as written. I remember when I was a young adult at the end of high school, my interests changed pretty rapidly, in terms of whether I wanted to be a poet or a pilot or a veterinarian, and that's the case for our children with disabilities as well. They're young adults just like everyone else, and their interests may change. So it's important that the IEP team be flexible and swift enough to account for those changes in interest and to update the plan accordingly as appropriate. Just as is the case with any other part of the IEP and this whole process, it is an individualized process. We're looking at this child and what their needs are, what their goals are, what their interests are. So this slide has a lot of words, and I'm going to go through it all with you here. But the ultimate point that's being made by this slide is that you are not required for your child to graduate. They do not have to graduate just because they turn 18 or because they've achieved all of the credits that they need to graduate. Okay, so there are a couple of different scenarios at play here. The first is your child turns 18, they're a senior in high school, and the other seniors in high school are graduating. You as well, your child as a student with a disability has the right under the IDEA and under Illinois law to continue to receive special education and related services up until age 22, or until the end of the school year in which they turn 22. So that is a decision that should be made by the IEP team and should be made based on whether the child has achieved all of the goals that they need and has acquired the skills that they need to accomplish their ultimate post-secondary goals, right? So they're ready to transition out, and they can't or should not just be pushed out of services either because they turned 18 or because they've satisfied the credit requirements or other graduation requirements from the school. And so, it's important to note too, I mentioned briefly, but there's the credit requirements of everyone at the school, and then there's the student's individual IEP goals. So even if the child has achieved their IEP goals and objectives for that year, that doesn't automatically mean that they need to graduate. Again, the school should be assessing their functioning and their needs. And if they still have needs, the plan should be updated with new goals to address those needs. Right? It's not, saying you've achieved the goals in this plan, so you're ready to graduate is somewhat arbitrary, right? Because those were the goals that were set at a particular point in time. And now we're at a new point in time later on down the line. And we really need to look at, okay, they've achieved those goals, but do they have ongoing needs that can be addressed by additional services and supports, or even additional academic instruction if that's necessary. So if you don't want your child to graduate, if you feel like they do still have those needs that should be addressed by the school district, you have to work that out as soon as possible ahead of graduation, or if it seems like the school district is going to push forward with graduation of your child, regardless of your pointing out their ongoing needs, then you can file a hearing request called a due process hearing request, or you could file a request for mediation. And either of those trigger a protection that's called stay put. Okay, and what stay put means is that once you file a complaint, the school cannot make changes to the child's placement as long as the complaint is pending. So if you file a complaint to challenge the fact that the school district wanted to graduate your child, then the school district is restricted from actually following through with that graduation while you fight over whether it's appropriate or not. That's called the stay put provision. So even if you file a due process, or even if you and the school district agree that your child should stay in school and receive services past 18, they do have a right to participate in the graduation ceremony with their peers. That is often, a monumental social moment for children, and our children with disabilities shouldn't be prohibited from participating in that milestone with their peers just because they're going to be continuing to receive services. So they can go through the graduation ceremony and wear the cap and gown and walk across the stage. That's all fine. But what you need to be careful of in that scenario is that you don't accept a diploma, right? Because once the school district hands your son or daughter a diploma and says, congratulations, you're graduated, that effectively means that they're graduated. So you need to make explicitly clear if they're participating in graduation, that it's for ceremonial purposes only, and that they won't be receiving a diploma. And if there's any gray area there, or if you're concerned that the school district may try something sneaky to give your child their diploma, then you may need to consider one, filing a due process complaint, or two, not having them participate in the graduation ceremony if that's a real risk. I'm gonna take a water break for a second. So on the topic of compensatory education, this is essentially a remedy for a school district's failure to provide appropriate services. So that can include a failure to provide appropriate transition services, or even an appropriate transition plan or evaluation. Whatever aspect or aspects of the transition planning process were faulty or inappropriate, you can potentially be entitled to compensatory education for that. The purpose of comp ed is to place a student in the position they would have been in if the school district had provided them appropriate services in the first place. Okay, so thinking about comp ed, it's not intended to be a windfall or a way to achieve more than the child would have if they received appropriate services. It's really looking at what did they miss out on, what was the effect of that, and how can we get them back to that position that they would have been in and should be in if the school district had provided appropriate services and not failed to do so. And comp ed can be a lot of different things. Again, it can be a creative planning process to determine how you're going to provide compensatory education. It can either be a specific service or a program, a private program like a therapeutic day school, or a private transition program even. The threshold though, when you and the school district together, or when a hearing officer, considering a due process complaint, is determining what the level or whether comp ed is needed, the threshold is whether the deprivation was significant enough to cause a lack of progress or a loss of educational benefit. So sometimes parents will ask me, gee, my kid they didn't have the plan in place for him during the first week of school, and we had to really push them to get their act together at the district and to implement the IEP. Can we get comp ed for that? I would say it depends. That's the classic lawyer response. It depends, but most likely no. Okay, 1 week of missed services is most likely not enough to cause a significant lack of progress or lack of educational benefit that can't be made up for once the services resume. Okay, so we're talking about something that's actually demonstrable or measurable in terms of, my child didn't get reading support that he needed for a whole semester, and really using the IEP goals. If you have measurable goals, this is part of why they're so important. If you look at the IEP goal that you set at the beginning of the year, and the IEP team, including the school district, agreed that the child would be able to, read at 5th grade level by the end of the year, and now you're coming up to the end of the year and they're still reading at 3rd grade level, then you have to ask, well, first, was that goal realistic based on the child's abilities? If it was realistic to expect them to reach that level and they didn't, why didn't they reach that level? Okay, was it because of a lack of services and supports? And if so, that would be a significant lack of progress that could entitle you to comp ed. Now, once you've determined that you have a lack of progress sufficient to entitle you to comp ed, you have to calculate how you're going to determine what services need to be implemented as comp ed. And the most common way that that's done is called the qualitative approach. So we're not saying that the child missed 30 hours of speech language services, so the school district needs to make up by giving them 30 additional hours of speech language services. That may end up being the appropriate amount to provide, but we don't calculate it on a one-to-one basis usually. The qualitative approach means placing the child in the same position they would have been in if not for the school district's violation. So if they can provide more intensive speech language services, that would get the child back to the level that they should have been in if they had achieved appropriate service, or if they had received appropriate services, then you wouldn't need to provide 30 hours just because they missed 30 hours. It's really about the quality of the services and how they're provided, not the number. So that's just a word of caution not to get too caught up in the numbers and focus more on what's necessary. And that's a question that you may be unable to answer on your own. In a lot of cases, it's quite likely that parents are unable to make that type of determination on their own. So in those cases, we would advise parents to consult with outside providers. If your child's working with a private speech language pathologist, or if you can find a private speech language pathologist to continue this example, you may want to get an evaluation done to determine what that person feels would be necessary to allow the child to make it back to the level that was expected for them to achieve. So I hope that makes sense on Comp Ed. I know it's kind of a heady and dense topic in a short amount of time. I'm happy to answer questions on it, but another sort of word of caution, or just a sense of perspective on it, and this comes into play a lot now with children who have returned to school after remote learning. Whether you consider what your child needs as compensatory education or not, the school district is required to consider the child's current needs, examine their progress, regression, or stagnation, and to craft an appropriate plan, right? At this time, what's needed at this time to allow my child to receive or to achieve the goals that have been set for them. Okay, so the mindset there is not saying, school district, you did something wrong and you need to pay us back with Comp Ed, but simply going through the normal IEP process. What does my child need now, and how do we plan around their current needs? Okay, so it's often easier to get a school district to provide appropriate services that way, when you're not essentially coming at them and saying, you did something wrong and you have to pay us back for it. That's sort of the message of what Comp Ed is, right? Because it's considered a remedy for a violation by the school district. So schools will sometimes bristle or push back if you talk about Comp Ed, because they don't want to admit fault. But it's easier for them to acknowledge what a child needs in the present moment, regardless of what happened in the past. So that's where I would start. And then if you're still getting pushback, then you may consider filing some sort of complaint to address compensatory education. And it is clearly established in the law that you have a right to Comp Ed for denial of appropriate transition services. These are a few examples I'll let you take a look at on your own, but it is certainly something that can be awarded. And actually, I've changed my mind about letting you look at it on your own, and just mention in the MM case, in the second bullet point, which again was the case that we litigated successfully for a child in the Evanston District 202, the hearing officer ordered additional time in a private transition program beyond what otherwise would have been required. So that means, that meant for that student, and I think on the next slide, yes, for other students, you can be entitled to services beyond 22. So even though 22 years old is the cutoff for services to be provided under an IEP, under the IDEA by the school district, there can be services beyond 22 as compensatory education to make up for what wasn't provided that should have been. And this can take a lot of different forms that we've talked about. Important to note, there's generally a 2-year statute of limitations, meaning that that you would need to file a complaint within 2 years of the date that you knew of the school district's violation of your child's rights. Okay, so if you're reaching, age 22 and your child is set to be graduated, you should try and assess whether you need to file a hearing request at that point, and not wait too long, because at some point down the line, generally 2 years down the line, you'll lose your rights to complain about things that occurred in the previous 2 years. Just a mention about Comp Ed due to COVID, and we already touched on this, but there should be a right for Comp Ed due to missed services when schools were shut down, but it's still not really clear how the state, the federal government, or the courts will respond to individual cases. I don't think that comp ed is going to be automatically awarded to students who missed services. I think you would have to demonstrate again that there was a denial and that denial had a significant impact on your child's performance. And so this is sort of still an untested or a broadly untested area. And I think it will ultimately still be determined on a case-by-case basis. So we've referenced ways to resolve disputes throughout, but just to make it explicit, if your school won't agree to provide services to account for your child's lack of progress or regression during remote learning, or if they refuse to make reasonable accommodations, or if they refuse to do anything that they're required to do that we've talked about throughout this presentation in terms of your rights to appropriate transition services, assessments, and plans. If you have any disputes with your school district about anything like that, if you have those disputes and you're unable to resolve them informally, just through conversations, requests for services, essentially if you're meeting a brick wall from the school district and they're not cooperating, or if they are cooperating but it's still not resolving the dispute and there's still issues, then your next step would be to either file a request for mediation or a due process hearing request or a state complaint. The first two, a mediation request and a due process hearing request, have the benefit of triggering that stay put protection that we talked about. If you're concerned about your child being graduated or removed from any type of placement or services, filing a complaint or a mediation request will trigger stay put. And then just to quickly differentiate the two, request for mediation is essentially just asking for a neutral third party to be assigned and to schedule a meeting called a mediation session where you and the school district meet with that neutral third party, the mediator, and they try and assist you in reaching a resolution of your dispute. So that unless you end with an agreement that's signed by the parties, nothing that's said at mediation or discussed is able to be disclosed. It's all confidential, but also there's nothing binding on you or the school district. So there are no obligations that need to be fulfilled unless you both agree to them. So that's a fairly informal process. If you file a mediation request, there's no guarantee that the school district will even agree to mediate, but oftentimes they do. And then a due process hearing request is a more formal complaint that you file where you outline your issues and concerns and request specific relief that may result in a mediation session being held after the complaint is filed. And then it could also go forward to an actual hearing where you present evidence and examine witnesses, just like a sort of a mini trial hearing. So now I'm going to turn it over to Holly to talk a little bit about these questions for consideration, and then I'll be happy to answer any questions that have come in during my presentation.
Thank you so much, Brad. This was so much very helpful information. Thank you to all of our attendees as well for your thoughtful questions. I will quickly touch upon some questions that we often receive about the need for additional outpatient services around transition age before we dive into more detail on the questions. I think in particular, one question that often comes up for us for families at AARTS is whether and when a reevaluation is necessary or can be helpful. Brad, thank you for passing on all that information about the required elements of a transition evaluation provided by the school district. I think for any outside evaluations, I think a key piece in consideration is thinking through both timing and the reason why any additional testing outside of school might be necessary. And I think a big piece of that is thinking through the difference in goal and the outcome of those evaluations. I think a main piece is thinking through the distinction between the educational evaluations provided by the school district and evaluations conducted in outpatient settings in consideration of medical diagnosis. And this goes to an underlying difference between some of the educational criteria for eligibility related for school-based services versus the medical criteria for diagnoses. So for example, for autism, in having an autism eligibility category on a child's IEP doesn't fully equate to the having a medical diagnosis of autism. The educational criteria for that autism eligibility actually don't directly map onto the diagnostic criteria for medical diagnosis. And in some cases, especially around this transition age, it can be important to make sure that there's a documented medical diagnosis for children, especially when considering eligibility for additional DHS or Social Security services in the future. And in thinking about some of that type of outside testing as a means to refine diagnoses and refine recommendations, not just in school, but also thinking through daily life. Oftentimes a key consideration that can prompt the need for an outside evaluation is if there are any really new concerns or any changes that you're noticing at home, any changes in behavior, fluctuation in skills, additional mental health concerns. Certainly it's true in the IDD population, just as in the general population, that additional mental health concerns certainly become more prevalent within the teenage years. For example, anxiety and depression can become additional concerns as children are aging into adolescence and young adulthood. And that type of additional diagnosis and psychiatric understanding is I think something that can be provided as part of these types of outside evaluations. And a key piece, certainly going back to what you had mentioned, Brad, is making sure that any of those outside evaluations and any outside evaluators also are supporting you as a family and the school team in maintaining those really open lines of communication to make sure that any findings from those outside of evaluations can be incorporated and taken into consideration as part of the IEP planning process.
Great, thank you. Can you advance the next slide? So we have a couple slides here. We're not going to go into detail because I do want to jump into questions. We've had a lot of really great ones come in, but we send out the slides. You can definitely reference back support services from district, where to access legal supports and recommended readings. Go ahead to the next slide. So I want to chat through questions. So Brad, you spoke on the idea of schools requiring schools to really broaden that scope of needs or goals continuing after completing credit requirements. We had quite a number of questions come in related to that I think could be helpful to chat through. So one question was whether or not an aide could be provided by the school district to attend community college classes in order to assess whether or not, or to assess what types of services would be most helpful in creating a successful college experience for that individual. And then related, we had a similar scenario where that aid was provided by the district, but the student was not allowed to receive credit for that class. So they were only able to take that class as an audit. Can you give a little background or information as to whether or not a district would be required to provide an aid, and then what the differences between auditing versus receiving credit for that class might be?
Sure. So just at the outset, to be clear, this is, I'm assuming, a student who had not yet graduated from high school, but was attending a college course as part of their transition programming, not because they were already in the college program overall, right? So certainly participating in those types of programs can be part of a transition plan. And I guess at the outset, it's kind of encouraging to hear that this school district was willing to do that. That's a good thing, and to provide an aid to do that. That providing an aid, if it's needed for the child to, or the young adult in this case, to receive an educational benefit, is absolutely something that can be provided as a service as a part of the student's IEP. So, the question is really what's needed for the child to receive an educational benefit. The way that the question was phrased, it sounds like this may have been sort of an exploratory period, to sort of a trial period, to see how this young adult did with an aid, if that was something that was actually necessary. So, I'm not sure what the terms were in the IEP or the transition plan about the provision of the aid, and whether that was just a trial period. But if something like that is included in the terms of the plan, that it will be provided for X amount of time and then assess. It's important that if you have a disagreement after that point about whether the aid was appropriate or not, you should not delay in filing a complaint or a request for mediation, because the stay put provision that we mentioned could potentially come into play to require them to continue providing that support if you need to argue about it. So that's just a side note. On the issue of getting credit versus just auditing the course, that really depends, I think, on the post-secondary institution, so the college program, and what they offer and how the student was enrolled in the program, right? If this program offers that type of auditing opportunity, and that's what was agreed upon to enroll the student, then there's sort of an understanding at the outset that they're not going to be getting credit for the course, versus if it was just a student enrolled in the course, and then they said later, well, you can't get credit for this course because I don't know what the justification is, because you have a disability, or because you're not completing all the requirements of the course. Then you may have a stronger case that there's a component of discrimination going on there. But I would have to know more about the facts of the case to say for sure. So I guess to answer the question as specifically as I can, there's nothing that should limit a child from receiving credit for a course that they participate in, unless there are specific requirements that they're not meeting, or an understanding at the outset of what's expected for them to receive.
That's so helpful. Thank you. And then still kind of on that idea of services, even after completing that credit requirement, we had a couple questions come in on the types of programming and whether or not there's a specific credentialing process for the types of programming that an individual might be able to participate in. So if there are essentially certain requirements on the type of transition programming that they might be engaged in.
I'm not familiar enough with the particular accreditation requirements for various agencies or programs. I would say, the school district may have a valid point if they're saying they can only pay for accredited programs. But again, that's very fact specific to the individual case. And I don't think that it should be just a blanket impediment or bar to using that service. So if you can explain or make your case for why this specific program is necessary for your child and why there is not a comparable accredited program available, then I think that's a very reasonable justification for using that program. Now, if you're talking about, two very comparable programs and one's accredited and one's not, that would make it harder to make the case that, for whatever reason, the parents prefer the non-accredited version.
And one other little bit more specific question that came in related to this was whether or not that you had spoken about districts setting aside funding for paying for certain programming or resources. And so a question came in on whether or not that those funds set aside by the district could be used to hire an outside group or program to create a business plan for a micro business, say, as a kind of building up a mini training program.
Yeah, I want to say yes to build a training program. And if that's, it sounds kind of like you're saying sort of like an experiential learning process, right? So thinking about it that way, if the goals are for this young adult to learn how to build a business, then yes, funds in an escrow account could be used to help develop that program. But again, it has to be part of the transition plan and the educational programming. I don't think you can just get a school district to pay to bankroll your business if it's not, specifically for an educational programming purpose that's tied into the goals in the transition plan.
Sure, that makes sense. Kind of shifting a little bit more to goal specific needs, and maybe this is just something you can follow up with after, but we had some participants ask whether or not you had examples of, or where they can find examples of well-written IEP transition goals that they might be able to reference or see to get a picture of what those might look like.
Yeah, I would say, it'd be kind of difficult for me to recite a goal, right now, and probably not as helpful as seeing it written out. So I don't know, Holly, if you want to, I can rustle something up and email it to you to share with interested folks, or
Yeah.
if at the same time, if anyone listening wants to contact me directly, I think my email address is in here, and you can reach out and ask me questions about that or anything else, after we get offline here.
Sure. Okay, great.
Here's my email address.
Wonderful.
Yep, it's in there.
We also had a little bit more of a specific question come in, so bear with me. I'm going to read or summarize it out loud, but an attendee's daughter's in high school and took some prerequisite classes to volunteer in the high school preschool program because her daughter has an interest in working and learning with little kids. Due to COVID, the preschool program is not taking any additional volunteers. And she was able to volunteer last year. Thoughts on what the school should or could offer?
I guess if there's an alternative preschool program that she could participate in, then that would be the easiest alternative of what could be offered. If it's the case that no such programs are taking new volunteers, then you may have to look, at least in the short term, at something that's less of a hands-on learning experience and more teaching the skills that would be necessary to have that kind of job. So, essentially serving the same purpose of learning the skills and of learning what it takes to do that job, but without actually being in the scenario where you're implementing the skills that you're learning. So that could be, more academic or instructional. It could also be creating role-playing scenarios where a staff member could work with your child on, implementing those skills. So they're still displaying them, still practicing actually using the skills, just in a role-play scenario, not in an authentic environment.
Okay. And if, just a point of clarification, I misread that daughter was not able to volunteer last year, and they are not able to volunteer this year because they're not taking new volunteers. I guess, what's the district's responsibility in being able to require or able to offer some sort of hands-on learning experience prior to transitioning out of services?
I would say it's not absolutely necessary in every circumstance. However, if, as is the case here, the team has determined that that this student should participate in that type of program, then I would say you may have a case for compensatory ed to say, we agreed that this was necessary. They were unable to provide it, maybe no fault of their own. Just circumstances with COVID, but it remains something that this child needs. So once it's available to be provided, it should be provided. And so then you've got questions of timing that come into play, and questions of whether the school district would be on board with providing that down the line. So all those would have to be, considered more directly, examined and addressed. But if this parent wants to talk more in depth, I'm happy to do that.
Okay, great. I had the same. We had a question submitted, and I had the same question pop up as you were chatting through graduation. We certainly have individuals who wish to graduate and walk across that stage with their peers and be part of that experience. But as you said, handing that diploma can then be a barrier to accessing services after. And one of the questions posed was, is there any legal reason why a principal, for example, or whoever's handing out that couldn't provide a similar experience, like a blank sheet of paper in a folder, out to the individual as they cross the stage? In this instance, they were, the principal said no, and they were denied. Is there any legal reason why they can't do that? And what kind of recourse an individual might have if the principal says no and they'd like to still?
There is no reason why they couldn't do that. And in fact, that is an example of a reasonable accommodation that could be provided to allow the child to have that full experience without actually receiving a diploma. I'm curious, is this principal saying, I can't give you a paper, but you're still welcome to do the graduation? Or are they saying you can't participate in the graduation at all?
It sounds like they were able to participate in their graduation, but just wouldn't be handed something on stage.
So that makes it less concerning, frankly, because they were still able to go through the process, albeit not the complete symbolic, transfer of a paper. But the bigger concern would be if they're barred from participating at all. Then you would have a stronger argument for discrimination on the basis of disability, potential retaliation, which are both violations of the student's rights under federal law.
Thank you. I think we have time for maybe 2 or 3 more questions. This one is a little bit more targeted towards Jen in terms of, but certainly, Brad, you might have some input on legal responsibility or financial obligation. But a question came in on whether or not schools are obligated to provide financial support if a reevaluation or evaluation is merited based on some of the reasons Jen had described: impacted functioning, a decline in functioning changes, things like that.
In most cases, usually the answer is no. And Brad, please feel free to offer additional notes. In many cases, I think as part of the transition evaluation process, as well as part of the triennial reevaluation process conducted by the school district. School district typically does have that responsibility to conduct those reevaluations. I think there sometimes can be a need for financial support provided by the school to fund an outside reevaluation if the district is not able to, does not have trained staff or sufficient expertise in order to adequately assess all of the areas needed as part of the evaluation process.
So I'll add just to briefly touch on the concept of an independent educational evaluation, or an IEE. So if a parent disagrees with a school evaluation that has taken place for various reasons, right? It could be that you disagree with the result, or you feel like it was a shoddy evaluation that didn't really touch on the areas of need that your child has. It could be that the evaluation was conducted at a time when your child was not capable of participating, and the results are skewed as a result. Or in some circumstances, although this is less certain, if the school district simply refuses to do their own evaluation. So either you disagree with an evaluation that the school district did, or they refuse to do an evaluation outright, you can request an independent educational evaluation, which is at school district expense, but you're picking the outside evaluator, you're arranging for the evaluation to be completed. When you make that request to the school district, one, it should be in writing, signed and dated. And in fact, I'd advise you to put as much of your communication with the school district in writing versus by phone, as much in writing as possible, just so in the event that there's any dispute about what was discussed in the future, you have a written record. That's just an advocacy tip overall. But in regard to independent evaluations, you need to make that request in writing. And when you do, the school district only has two potential responses under the law that are allowed. And those are to either honor the request, to say, okay, you can get an independent evaluation, or to say, no, our evaluation was appropriate, and we're going to file a hearing request to essentially get a hearing officer to declare that our evaluation was appropriate.
So helpful. We will, let's see. Another question that came in, more COVID specific, but I think with the transition back to in-person services, we've seen certainly a variety of responses, but some students with more sensitive sensory experiences might have difficulty engaging while wearing a mask. And a question came in on how adult programs and some of those vocational programs are responding related to working with students who have difficulty wearing a mask, but have a mask mandate in place. Can you speak a little bit to that?
Sure. So there may be some variations on what I'm about to say, depending on the specific program or location of where the mask mandate is, or what's going on there. But in schools specifically, a student with a disability cannot be excluded from in-person learning because of an inability to wear a mask for disability-related reasons. So if your student can't keep their mask on for sensory reasons, or if they simply don't understand the purpose of the mask, and they may be, moving it around impulsively, whatever the case may be, that's not a reason to bar them from participating in school. The most common alternative to a mask is a face shield, but that may have the same sensory complications for kids. In that case, or in either case, the accommodation would be to strictly maintain social distancing, and to explain in a sensitive way to others in the classroom or in the program why this student can't wear a mask, and also to include that in the IEP or in a behavior plan, so it's clear that this is a disability-related issue and that the student shouldn't be punished for their inability to wear a mask. It's also the case, though, that if, say, the student is doing a job training program at a restaurant, and the restaurant requires all staff to wear masks, and this student can't wear a mask, they may be restricted from participating in that. And that really would depend on how the program is organized. Is it a part of the school, or is it just an arrangement with a private facility or private restaurant? They wouldn't be held to the same requirements as the school itself would. And then I should also just point out that in a case like that, it can be very helpful to have documentation from a doctor or a private clinician who's working with the child, just to support the fact that the inability to wear the mask or keep it on is related to their disability.
Which I know is a conversation we probably could have speak a lot longer to.
Yeah.
But just in the sake of time, this will be our last question, and certainly please reach out if you have follow-up questions. But would you be able to speak briefly to the difference in terms of transition services available based on placement? So based on a public school setting versus a private school setting, and any differences in what students are or what the private school placements are required to provide, and whether or not there's a person or contact that can provide consultation to parents on that.
So in general, private schools are not subject to the IDEA, the federal law that governs public school settings. Private school, so everything that we've essentially talked about in terms of transition obligations does not specifically apply to private schools. However, private schools are required to not discriminate against children with disabilities. So if the private school offers experiential learning programs, or anything that would fall under the sort of the umbrella of transition services, if that's something that's offered to their students just as a part of their program, it must also be offered to your child with a disability. And if that means providing specific accommodations to allow your child to benefit equally from that program, if that means a one-on-one aid, if that means extra instruction to teach them how to do any of the, or to use any of the skills that are necessary for that type of program, you have an argument that those have to be provided in order to avoid discriminating against your child, or not providing them with equal access to the programs that non-disabled children receive.
Wonderful. Well, we are going to stop there again, just to be mindful of time. So I want to thank you for sharing your knowledge, your expertise in walking through some of these questions that folks had. We will be sending out a recording link to the presentation as well as slides. So Brad's contact information as well as our contact information will be in there. Thank you again, and do reach out. For all of our attendees, reach out if you have questions.
Thanks, everyone.